Welcome to the Digital Planning Podcast. This series is designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. To keep up with all things digital, please subscribe at iTunes, Stitcher, Google Play, or wherever you download your podcasts. And now, Jennifer Ziegel, a partner at Kleinbart LLC, Ross Bruck, a principal of Estate Genie, and Justin Brown, a partner at Pepper Hamilton LLP, with today's topic.
Welcome to the latest episode of the Digital Planning Podcast. I'm Ross, here with my co-hosts Jen and Justin. Today we're going to be talking about creating an inventory of digital assets and some of the advantages and disadvantages of multiple approaches. So Jen and Justin, you're both practicing attorneys. When a client comes to you and says, help, how do I keep track of all of my digital assets? What should I do for my passwords? Where should I turn to for help in organizing my entire digital life? What's the first reaction you have, and what's the first thing you say to them to put them in the right direction?
So the first thing that I talk about is creating an inventory of all of your digital assets. And by digital assets, I mean all of your usernames and passwords and everything, so that it's easily accessible. And there are different schools of thought as to how to inventory everything. There's a debate. Should you use a paper inventory or should you use an electronic inventory? And when we say paper inventory, we mean essentially you write down your username and password on a piece of paper, and every time you get a new username or password, you write it on that piece of paper. Electronic inventory would be there's some type of electronic mechanism that you're using to record your username and password, whether that is automatic or if it's manual. So for example, the paper would be you write it down. Digital could be you type it down in, say, a Word document or some type of electronic medium, or it could also be using a username or password manager that will automatically inventory everything for you. There are different pros and cons to using both. Let's take a look at paper first. One of the great things about paper is that it's relatively safe. You can store it in a safe deposit box. You can store it in with an attorney. There are different options for storage. You don't have to worry about anybody hacking into a computer or hacking into a program or hacking into a network. It's there. One of the downsides is what happens if you lose the piece of paper, or what happens if you destroy the piece of paper. I know that I have some clients who've decided to write everything down on a piece of paper, which is all well and good, but what happens when you spill your coffee on your digital inventory page and you've ruined your digital inventory page? Or what if nobody knows where you placed your digital inventory page? So various pros and cons. Another issue with a written document is you have to be diligent in recording the inventory information every time your username or password changes. We have, I will say, hundreds of usernames and passwords that we use on a regular basis on various websites and various accounts, and sometimes those accounts require us to update our username and password with logins on a regular basis. So if you use a paper source of inventorying, you have to be very diligent about updating your username and password every single time it gets updated.
I'll throw a little more on there that you said it's secure, but after the user passes, the executor or some family members may be going through and searching through their files, and that paper being among those files may lead to the wrong person getting control of those accounts before the person who actually has control or should have control being able to have access to them.
Absolutely. We've talked in other episodes about the obligations of executors to access and what they need to do in order to access digital assets. And we've thrown out the idea that some of the laws, people are sometimes unaware of the laws and who may access that information. So if I'm somebody who comes across this piece of paper that has the decedent's usernames and passwords, and I'm inexperienced with the Stored Communications Act or the Computer Fraud and Abuse Act or the Revised Uniform Fiduciary Access Digital Assets Act, then I may believe that I can just log into the decedent's accounts using the usernames and passwords listed on that paper.
And of all the problems you just listed, for me, the biggest problem is keeping it up to date. It's a struggle to have an individual constantly update that piece of paper, especially with the growing number of accounts. And that's a burden, at least in my eyes. Maybe that's not true for every single client that you guys come in contact with. And some are more organized and willing to devote the time and attention to keeping that up to date.
See, I take a slightly different approach. I think for clients who want to explore digital asset planning, definitely creating an inventory is the first step, but I view the inventory as being an inventory for multiple purposes. So one, you would have one for username and passwords, which Justin just discussed. But two, I think you should have a separate inventory that actually lists all of the digital assets, not including username and password information. So if somebody was holding cryptocurrency, it would say, 10 Bitcoins or, 12 Ethereums or gaming tokens, and it would actually list all of the different items that are considered digital assets. Then you'd have a separate list of all of the devices that the person has, how many computers they have, how many phones, tablets, other types of external hard drives. So that's categorized and recorded. And then have a separate list for password management and username and login information. And I don't think all of those three types of lists should be kept together. And this is where it gets really tricky, especially for clients who have a lot of digital assets or could have a lot of digital assets appreciate in value, as to how to store all of this information, but also have it accessible without too many hurdles if needed.
So, related question, client comes to either of you and says, Jan, Justin, will you please store this copy of all of my passwords and my accounts in my file? Are you accepting that paper? Are you turning it down? Are you maybe moving on to one of our other topics of using electronic formats or third-party custodians to manage those accounts and that information?
So for me, and let's just also say for some of the people listening out there who may not do estate planning, as an estate planning attorney, I will frequently hold the wills of my client or the estate planning documents of my client in a vault. And it's very common for estates attorneys to hold their clients' documents in a vault. So I guess, Ross, your question is, do we extend that principle and hold their usernames and passwords or an inventory of their digital assets inside of our vault also? And I think Jen's solution is by having different lists is something that I would feel a little bit more comfortable with. And let me explain. I feel comfortable holding a list of the actual assets that somebody has because, quite frankly, in the course of estate planning, I'm obtaining that information anyway. Mm-hmm. I'm obtaining account numbers, I'm obtaining sensitive information from them and storing that in what we like to believe is a secure manner. Hopefully it is. So I don't have a problem saying this person has X number of Bitcoin. I think my problem arises by holding the usernames and passwords because I, as the attorney, do not want to be responsible for any data breaches that may be associated with improper access to digital assets. So it is my policy as an estates attorney to not hold the usernames and passwords for protection purposes. Quite frankly, I don't want to be responsible for updating usernames and passwords every single time my client changes a password.
I completely agree. holding the actual inventory of all of the digital assets, I have no problem with. In our Will Vaults, we often will hold marriage certificates or share stock certificates for companies, for clients, or original deeds. So an inventory list of digital assets is definitely something that wouldn't be a problem, but I definitely agree with Justin that holding the actual username and login information is not something that I would want to do for a lot of different liability purposes, or in the event there was some type of bad actor, I don't want to be responsible for any types of breaches or assisting somebody to access accounts without proper legal authorization.
So let's now talk about electronic storage. And the various different ways that somebody could store an inventory. And when we say inventory, now let's think in terms of Jen's definition of inventory, which includes username and passwords and a list of accounts
And devices.
and devices. So electronic storage would be using some type of electronic means to store the information. You could just use a Word file, but I view that as more of paper storage because you can print it out and have it stored someplace. But the other option would be having it stored on either your server, the user's server, or using some other type of cloud-based storage mechanism to store this information. And this is an extension of the paper storage, right? Instead of printing out a copy, you're just storing it electronically, right? This would not be using a service that's sole purpose is to store and gather usernames and passwords and electronic information. So I'm thinking, for example, of you write a Word document listing everything and then put it on your iCloud account. And you've stored it on an iCloud account, which you can now access when you are on your computer. You can access it through your phone. You can update it on a regular basis. The advantage to this is that it is easily accessible. It is easy to update, which one of Ross's issues is how do we keep this thing updated? So it addresses that issue. Easier to update.
I still wouldn't go as far as easy because it's not automated the way that we might find with third-party custodians that we'll talk about in a little bit.
Right.
There's still effort involved, and there's still the struggle of you created this new account. Did you remember to put it on this drive? You updated this password. Did you remember to do that?
But it solves the problem of I stored my password, my inventory list with my attorney, and now I have to contact my attorney and to have my attorney update it, or I stored it in my safe deposit box and I got to go to my safe deposit box and update my list. Right now, so now it's easier in that you can just do it yourself on the go.
And that might apply also, I'm thinking, either the iCloud, maybe you're sharing a Word document, Dropbox, you're sharing something, Google Drive, maybe you're giving right access to both spouses, and so husband and wife each create their lists and share it together on a shared drive. That's giving multiple points of access to that single document and making updating also easier.
And in the event that one of the computers crashes or malfunctions, you still have it stored accessibly in a cloud, which if you have it just privately on your personal computer, if there is some type of crash or hack of your computer, the list could be gone or in jeopardy.
So one of the big problems with this type of storage is the access issue that we've discussed after somebody passes away. Whatever service is used is the decedent is going to be subject to the terms of service agreement for that specific service, and depending upon whether we're in a rufata state or a non-rufata state, that will determine the executor's ability to access the information. So just because it's stored and it's more convenient, it's easier to use, it still could create the problem of how do we access this information after somebody has passed away? Is there an online tool in the mechanism that was being used to store the information? If there wasn't, did the decedent provide lawful consent in his or her will? And in the absence of an online tool and lawful consent under RUFADA, what do the terms of service provide, right?
And just to refresh some of the memories of our listeners or for people who are just tuning in, an online tool is an agreement with the user and a custodian that's separate from the terms of service agreement that allows the user to authorize or not authorize the access of the user's account and or digital assets at death or incapacity.
And you mentioned it before, but it bears repeating that when attorneys are giving legal advice, in the realm of discussing passwords with clients, they still have to keep in mind the federal rules that are guiding this entire subject matter, specifically the Stored Communications Act and Computer Fraud and Abuse Act, and staying within the guidelines of those when offering legal advice to your clients.
Exactly, and if the recommendation is for somebody to store it in one of these cloud-based storage programs, we probably, as attorneys, also need to be aware of what the terms of service agreements are for these individual storage companies. The Dropbox terms of service agreement may be very different from the iCloud terms of service agreement, which may be very different from the Google Drive. So it's not as simple as saying to your client, oh, just store it in a cloud, right? It's maybe there are better options than others in order to store our inventories.
And just to follow up on that, every single terms of service agreement that I've read has a provision that essentially says the terms of service agreement is subject to change and continuing use of the service is deemed to be consent to the amendments to the terms of service agreement.
So let's now shift to the third type of storage. So we've done paper, we've done electronic, and the third type of storage would be using an actual electronic manager to manage usernames, passwords, inventories, and listings of our digital assets. This third option is probably the best, I will say, from Ross's perspective, because it's easily updatable. These types of, and I'm not going to single out Ross, I'll say me too. But these types of managers are usually very easy to use. There's usually an extension in an internet browser that will allow somebody to automatically update usernames and passwords when they go to various websites. So here's how this works. You set up an account with some company and you put your usernames and passwords in, and when you go to a website, it will automatically recognize that you have usernames and passwords in that website. Or if you go to a new website, it will automatically upload those usernames and passwords or update those usernames and passwords to their site, so that you have a running list of all of your usernames and passwords that is easily accessible to you on a computer, on a tablet, or on your smartphone. Big positive to this is it's very easy to access while you're alive. It's very easy to update. And it takes all of the responsibility of maintaining this inventory out of the hands of the user and puts it on the company or the provider who is storing all of the information.
And to play devil's advocate, for some clients that might be a very uncomfortable option because they don't want all of their sensitive personal information and access information held by a third party that could be subject to hacking or tampering or security and data breaches.
Or bankruptcy.
Or bankruptcy. What happens in that situation if the company is a fly-by-night operation, all of the data information for a particular client is stored there, there is no secondary backup list. It could be very cumbersome for a person to reset all of their username or passwords, or what if something like that coincided with that person's disability, incapacity, or death? How would those types of accounts be recreated to their fiduciaries to understand where they're located, and that there could be digital assets that need to be accessed, or even accounts that need to be closed at death to preserve the digital identity of the person?
Yeah, I think a lot of people are very skeptical about using them for the reasons you said, and for Ross, the bankruptcy issue. What if the company goes under, and what happens to everything, or hacked? But nonetheless, there are many reputable companies out there who do this and provide this service. And if we go to the next issue, would be when the person dies and they're using one of these services, what are the mechanisms for accessing, right? Some of these companies may have online tools. Some of these may have emergency access tools, which could be in existence during somebody's life or at their death. But I think you still need to provide lawful consent in one's will in order to be able to access this information. And again, we're still subject to the terms of service agreement of these companies. So, as I said before, it's not as simple as just saying, telling our clients to just go use a password manager. We need to know more about what these password managers say, what their terms of service agreements are, because there might be some that deal with death better than others.
Absolutely. There is no one-size-fits-all approach when addressing this type of topic with clients. I mean, people have varying degrees of digital assets with varying values. They have different definitions of security and different levels of comfort with technology. So there is no one-size-fits-all approach to planning with digital assets, especially with creating inventories.
Well, regardless of what mechanism you use, I think we could all agree that there needs to be some kind of inventory mechanism that people and clients need to be using in order to keep track of all of their digital assets.
Agreed. I'll throw in one more idea, open a can of worms that we can't possibly answer in this episode. Maybe we'll devote a future episode to this idea. But a lot of the big tech players are looking into a world without passwords, accessing using biometrics or other mechanisms that aren't the written password. So this is a continually evolving world and subject that everyone needs to pay attention to and look at latest developments, because even a digital asset clause acknowledging passwords right now, or using one of these online providers, or using the basic paper that we talked about to store passwords might not apply in 10 years, and everything will be turned on its head.
That's a great point. I think digital forensic identity is in vogue right now. A lot of different service providers are exploring what options that type of technology would have on all different types of digital assets and accounts. And it's very important, as a rule of thumb, to review all of these types of estate planning clauses, provisions, digital asset inventories, at least every 3 to 5 years, if not sooner, especially if there are life-changing events or major technological developments. That would be another point in time to completely review and analyze whether the current planning structure is still appropriate.
Thank you very much for joining us for this episode of the Digital Planning Podcast. Join us next time where we talk about the ownership of digital assets.
Thank you for listening to this episode of the Digital Planning Podcast, the podcast designed to educate individuals about all things digital in connection with estate planning, business planning, and estate administration. Please subscribe to this podcast and leave us a rating or review at iTunes, Stitcher, Google Play, or wherever you download your podcasts. Thanks for joining us. We'll see you next time.